Just ahead on One Detroit, University of Michigan law professor Barbara McQuade weighs in on the controversial U.S. Supreme Court draft opinion that could overturn Roe v. Wade. Plus, the president of the Greater Grand Rapids NAACP and co-founder of Black Lives Matter Detroit talk about police reform and race relations after the fatal shooting of Patrick Lyoya by a police officer. And we'll continue our recognition of Asian American and Pacific Islander Heritage Month with a conversation about systemic racism after the murder of George Floyd. It's all coming up next on One Detroit.
From Delta Faucets to Behr Paint, Masco Corporation is proud to deliver products that enhance the way consumers all over the world experience and enjoy their living spaces. Masco, serving Michigan communities since 1929. Support for this program is provided by the Cynthia and Edsel Ford Fund for Journalism at Detroit Public TV, the Kresge Foundation.
The DTE Foundation is a proud sponsor of Detroit Public TV, among the state's largest foundations committed to Michigan-focused giving. We support organizations that are doing exceptional work in our state. Visit dtefoundation.com to learn more.
Nissan Foundation and viewers like you.
Just ahead on this week's One Detroit, George Floyd's murder at the hands of a police officer led to protests and conversation about law enforcement's interaction with people of color. We'll hear from an Asian American about this nation's troubled history of racism as we continue our series of AAPI stories. Plus, we'll talk about police reform and race relations in West Michigan following the fatal shooting of an unarmed black man by a white police officer in Grand Rapids. American Black Journal sits down with the president of the Greater Grand Rapids NAACP and the co-founder of Black Lives Matter Detroit. But first up, the investigation continues into who leaked a U.S. Supreme Court draft opinion suggesting Roe v. Wade could be overturned later this year. One Detroit senior producer Bill Kubota spoke with University of Michigan law professor Barbara McQuade about the security breach and what could happen in Michigan if the landmark 1973 court decision granting federal protection of abortion rights is struck down.
Barbara McQuade, professor of law, University of Michigan, former U.S. attorney for Michigan. Thanks for talking to One Detroit.
Oh, you bet, Bill. Thanks for having me.
We're talking the latest about abortion, the draft opinion regarding the overturning of Roe versus Wade being leaked. Leak, is that a common thing? And why would that happen?
Well, first, I think the substance of the opinion is the big news here, that there is this seismic shift apparently coming in reproductive rights in America. But the leak is highly unusual. You know, historically, there have been some verbal leaks of the way the court was going to be making a decision or that somebody wouldn't be joining the majority. But this is the first time ever that an entire draft opinion that in hard copy has been leaked to reporters. And I think it is a very significant matter. It, I think, will tend to undermine the public confidence in the Supreme Court. It tends to show that there is less internal respect than I think we had previously thought. I think there are theories that conservatives wanted to do this to lock in those votes, or liberals wanted to do this to generate outrage and create public pressure to change. But I think that you have to also expand the scope to think about who had access to this. Could it have been someone working from home where a friend or family member or household worker got a hold of it? Could it have been obtained in a hack? I mean, hostile foreign adversaries love to find wedge issues in America and exploit people, you know, the stealing of emails and other kinds of things. So I think that we should not make any assumptions about who might have leaked it.
How soon do you think we'll see an actual ruling?
Typically, in these very significant cases, they come out very late in the Supreme Court's term, and that's because they are exchanging these drafts. This looks to be a first draft. Some of the language is quite strong, and what often happens is, as it gets circulated, either votes change or some justices want certain language removed or certain language inserted, and it often gets a little softer. Some of those hard edges get rubbed off. And so typically the court ends its term in late June. Sometimes it's spilled even into July. just to give them sufficient time to exchange those drafts and get the final version out the door.
Legal folks say the Supreme Court will allow states to make any law they want regarding abortion. In Michigan, it gets a little complicated. We've had an abortion law on the books since 1931, lying dormant since the Roe decision. And then here in Michigan, you're looking at what we'd almost consider an ancient law that might take effect. Talk about that.
Yes. So there are two types of laws that are already on the books. One are what are called trigger laws. About 13 states have those. And those laws were passed after 1973 that say if Roe is ever overturned, these laws will go in place and they ban abortion. Michigan has a different category of laws. About a dozen states have these, and they're sometimes being referred to now as zombie laws. That is, they're ancient, as you say, but they're coming back from the dead. They were on the books at the time Roe was decided in 1973, but they became moot once that decision was made because it said that they were no longer good law. So they've lingered there on the books all this time. And if and when this decision becomes final and Roe is overturned, then those laws will revert back. So Michigan, we have one, it's a 1931 law that makes it a felony for a provider, a healthcare provider, to perform an abortion. Now, what's interesting about Michigan's law is the language of the statute is a little dated. It talks about things like causing a miscarriage, which isn't exactly what happens in all abortion cases. And so it may be that there are problems with that statute. It may be unconstitutionally vague. And in fact, our governor, Governor Whitmer, has already filed a lawsuit saying that that statute violates the Michigan Constitution under the Due Process Clause and the Equal Protection Clause of the Michigan Constitution. So that's before the state Supreme Court. Is that the case? So we have another Supreme Court that's going to potentially affect all of this. Yes, I think one thing that's important to understand is that all of us are protected by the U.S. Constitution. That is, the safety net that protects us from either federal or state laws that might overreach and violate our constitutional rights. But every state also has its own constitution, and that state can create even more protections than the federal constitution or different protections. And so in Michigan, we have a very different document. And what's interesting about Michigan's constitution is it was enacted in 1963, which is after this 1931 statute. And so it is quite possible that it wasn't contemplating, the people who wrote the statute were certainly not contemplating this constitution when they enacted the bill. There are other state constitutions, including California, that explicitly protect the right to an abortion. There are concerns the Supreme Court could put other rights at risk. Rights not explicitly written into the Constitution, but accepted now. Think birth control, interracial marriage, things connected to the Roe decision. And so what Roe held is that there is this right of privacy that's not explicitly included in the Constitution, but it is presumed. There's a Ninth Amendment provision that says rights that are not enumerated are reserved for the people. And so Roe is based on that concept. But since that time, the court has also used that same reasoning to find privacy rights that extend to the right to contraceptives, the right to interracial marriage, the right to same-sex marriage. And so if you take away that grounding of that right to privacy, then all of those other things are built on a shaky foundation and might fall as well. Are you concerned that that might actually happen? I think that it's difficult to say. The courts only decide cases that are in front of them. In this draft written by Justice Sam Alito, he does address these things and say these things are different. We're not deciding those things today. But that will later be dismissed as mere dicta, which is language in the speech, in the case that's not controlling. And so I'm sure we will get those challenges. I'm sure we will find states that want to pass those laws. We have some very aggressive conservative lawmakers in states like Florida and Texas who are looking to make a name for themselves in conservative political circles. And so, enacting a law on those bases will work its way through the courts. And, I'm sure they would be challenged. And then we would find out. Well, I suspect we'll want to check in with you again as these things move along. Barbara McQuade, law professor at the University of Michigan, thanks for talking to One Detroit. Thank you, Bill.